All right, I think we're ready to begin. My name is Andrew Summer. I'm the managing partner of the California practice at Carey, and I want to thank you for joining our annual California employment law update. We always look forward to this presentation, quite frankly, to make sure we're up to speed with all the new developments in California employment law and impart that information to our clients and friends. The California legislature over the past decade at least has been very active in adding new employment laws to the books, and this year has been no exception. It does seem like it was a little less substantive than it was the last 2 years, but there are a couple or 2 or 3 laws in particular that have very broad application that are going to be significant for California employers, and other ones that might be more technical or tailored to specific industries. In any case, as some background on our firm, Carey is a nationwide labor and employment firm. We provide counsel and litigation defense to employers, as well as defense in OSHA workplace safety enforcement proceedings. I am pleased to be joined by my colleagues, Megan Shaked and Samuel Rose from our California offices, who are well-versed California employment attorneys in both the litigation and OSHA defense fields. In any case, let's just forge ahead. There is a copy of the slides that's been placed in the chat function. We have our bios. We won't walk through them just since we have quite a bit of content to cover today, but you can always reference those bios for our background and always reach out to us individually should you have any questions. In any case, our agenda for today very broadly. First, Megan is going to discuss the new pay equity requirements, which are quite significant and will affect essentially all California employers. And she will cover as well the expanded leave requirements in California. We have had ever expanding leave requirements in California over the last number of years, and this year has been no exception to that. And then we will cover the various sexual violence, human trafficking prevention requirements that are tailored to very specific industries that Sam will address. And then we will address the new employee protections for cannabis use that impact the workplace, as well as kind of a medley of different new employment laws in the workplace safety, wage and hour fields, as well as some other very specific areas. So with that, I'm going to turn it over to Megan to discuss the new pay equity requirements.
Thanks, Andrew. So California pay equity laws are not new to California, but there are some very significant changes for this year. And this new law, Senate Bill 1162, took effect January 1, 2023. So just as a little bit of background, there are existing, so there's 2 aspects to the pay equity bill that I'll be discussing today. One is a reporting requirement, and one is the pay transparency requirement. So for the reporting requirement, there was an existing requirement for employers with 100 or more employees to submit pay data reports to the California State Agency, which has changed its name to the California Civil Rights Department. And those reports have to be made by employers with 100 or more employees, or who have 100 or more labor contractors. And they have to submit this pay data report by certain deadlines. For this year, it's the second Wednesday of May, and then it'll be the second Wednesday of May in subsequent years. That date has changed. So the pay reporting data deadline is now the second Wednesday of May if you're tracking a different deadline. And that pay data report has to include both the mean and the median hourly rate for certain categories of employees. So race, ethnicity, and sex within any enumerated job category. And job categories would be, things like executive senior level or, the administrative support team or the service workers. And so this information has to be submitted, and the submission requirement itself, generally speaking, is not new, but there's little aspects of it that have changed, like the deadline, who has to submit the data. It used to be that employers with multiple establishments had to submit their pay data report for each establishment, as well as a consolidated report. So that consolidated report requirement has gone away. But it used to be that employers could use, in lieu of the pay data report, the EEO-1 form in order to meet your compliance requirements for this. And that is no longer allowed. So it does have to be a separate pay data report that is submitted. You can't simply rely on the EEO-1 any longer. So that is the updates to the pay data reporting requirement. And then there is an additional added requirement to the pay transparency requirements. So what it already was on the books is that employers, upon reasonable request, had to provide the pay scale for a position for an applicant, and then also for an employee. So if an applicant came to an employer and requests the pay scale data, that had to be provided. Or if an employee came and asked for the pay scale for their job position, that had to be provided. But now what's new is that any employer with 15 or more employees must include the pay scale for any position that's being posted. So if you're posting a job, online or on your company website, on a job board, that has to include the pay scale for that position. Not only that, but if an employer is using a third party to post the job posting, then the employer is obligated to provide the pay scale to the third party, who must then include the pay scale in the job posting. And the legislation itself defines pay scale to mean the salary or hourly wage range that the employer reasonably expects to pay for the position. And I'll talk in a few slides. The Labor Commissioner has issued some frequently asked questions that provide some additional information, but the pay scale definition is generally as provided in the legislation itself. And then there's also a record keeping requirement. So employers have to maintain the records of the job title and the wage rate history for each employee, for the employees. So this isn't necessarily from the job postings, but from the actual employees, for the duration of each employee's employment plus 3 years. And those records are subject to inspection by the Labor Commissioner. And one other interesting aspect to the bill is we're always looking out for these rebuttable presumptions that are oftentimes written into the law. And here there is a rebuttable presumption in favor of an employee's claim if an employer fails to keep records in violation of the provisions. So then the employer would have an increased burden to establish if there were any claim related to the pay scale and they weren't provided in the postings, then that would be an additional hurdle for an employer in a pay equity type case. So like I said, the Labor Commissioner has had a frequently asked questions page on pay equity, since again, pay equity is not new to California, but they were updated in December of 2022. They do not specifically reference this new law. Well, actually, that's not entirely true. There are quite a few FAQs that are not about this aspect of the pay equity law in California, but towards the end, there have been some additions that specifically address some of the anticipated questions that have been raised with this new change. So one, of course, is is what it means to include the pay scale in the job posting. They've clarified that it has to be in the actual job posting, and that it has to be included in the job posting if that position could be filled in California, either in person or remotely. And the information has to be provided in the posting itself. It's not adequate to include a link to a salary range or include a QR code that would then take a person to another web page that would have the pay scale information. So it has to be included in the job posting itself. They have clarified, since the legislation does not specify who counts as an employee for determining whether or not there are 15 or more employees. In California, the labor commissioner has deferred to the same definition that the same position that they take with respect to other laws that don't specify, like paid sick leave, where if there's at least one employee who is currently located in California, but the employer-wide has 15 or more, then this requirement will be triggered. And then there are a couple of frequently asked questions that also clarify the meaning of pay scale. So the labor commissioner has clarified that an employer who intends to pay a set hourly amount or a set piece rate amount must provide that set amount. And then there is a specific question about whether the pay scale has to include bonuses or tips or other similar benefits. And the answer there is no. If it's in addition to a salary or hourly wage, that does not need to be included in the pay scale. But if the position is if the pay is based on a piece rate or commission, then that piece rate commission range that's reasonably expected to be paid does need to be included in the job posting. So really detailed piece of legislation, a lot of specifics to follow. And luckily, the labor commissioner acknowledges that and has issued some helpful guidance. Like Andrew said, we've also had a slow but steady expansion of the leave laws in California. One in particular is the California Family Rights Act, which is not identical to, but can be thought of as a corollary to the federal FMLA Act. And, originally you kind of had a trigger for CFRA because it was 50 or more. That has been long gone. And CFRA applies to generally employers of any size, 5 or up. This year brings a specific expansion in the area of bereavement leave. So there has not been any California legislation specifically covering bereavement leave until now. And Assembly Bill 1949 requires bereavement leave of up to 5 days for employees who are eligible under CFRA. And for this purpose, they have to have been employed for at least 30 days before the leave begins. And the bereavement leave covers death of a family member, and family members specifically defined in the legislation. There's some other limitations on the leave. For example, it has to be completed within 3 months of the date of death. The legislation specifies that it does not need to be taken on consecutive days. And then acknowledging that many employers have pre-existing bereavement policies, the legislation also specifies that if an employer has an existing bereavement leave policy, that the leave must be taken pursuant to that leave. So for example, if an employer currently provides 3 days of paid bereavement leave, then the requirement here would be continue to pay those 3 days, but they would have up to 5 days of protected bereavement leave. If there's no existing policy, there's no existing employer allotment of paid bereavement leave, then the leave is allowed to be unpaid. or an employee can apply any accrued compensatory time that they may have on the books. If they have, sick time or vacation time or some other paid time off allotment that they want to use, they can use it for this purpose. As with any CFRA leave, there's no employers not permitted to engage in discrimination or retaliation or interfere with an employee's ability to take bereavement leave. And, to the extent possible, the employee's the confidentiality should be maintained. So, who the family member is or what the circumstances of the leave should be maintained as confidential. And there's a small carve out in this requirement if employees are covered by a collective bargaining agreement that provides similar type benefits, then there would be a carve out from this requirement. But generally speaking, protected bereavement leave is now on the table for employers covered by CFRA. There are two other expansions of leave in California that came to be through Assembly Bill 1041. The first, they both have to do with a designated person. And now under both CFRA and also under California paid sick leave, an employee is permitted to take leave to care for a designated person. In addition to the family members who are otherwise covered by the ability to take a protected CFRA leave to care for a family member, an employee can designate a person. And so for purposes of CFRA leave, that designated person is defined as an individual related by blood or whose association with the employee is the equivalent of a family relationship. Remains to be seen how that might be interpreted or how that might play into people's requests, but that's the definition under CFRA. An employee can identify who this designated person is when the employee requests their leave, but an employer is permitted to limit an employee to one designated person in a 12-month period of time. For paid sick leave purposes, there's a similar ability for an employee to identify their designated person when they request their paid sick days off. And again, the employer can limit the designated the designated person for purpose of sick leave at the, can limit it to one person within a 12-month period of time. There is an interesting Senate Bill 1044. Now, I'll just say from the very beginning that this does not have to do with the health pandemic. So this is not intended to protect employees in conditions having to do with COVID-19, but there is an emergency leave provision that was added to the books that provides a specific protection for employees who feel the need to leave the workplace during an emergency condition. It precludes an employer from taking any adverse action against an employee who refuses to report to work or leaves the workplace during a defined emergency condition. So this would be conditions of a disaster or extreme peril at the workplace caused by natural forces or a criminal act or a specific order to evacuate a site due to a natural disaster or a criminal act. And there are, as you would imagine, carve-outs for emergency people who provide emergency services. But this is another emergency leave protection that is now on the books for employees, just something to be aware of in case any situation might arise that would trigger this requirement. There's from time to time minor changes to the military leave acts. There was a very small change that clarified that employers that there's military leave entitlements under certain circumstances. There was a small carve out for inactive or active training. So there's, leave allotments for military purposes during in certain circumstances. And it used to arguably cover active or inactive training drills, but there's been a slight carve out for that. So depending on how specific your, handbooks might be in outlining the entitlements to military leave, this might be something you would look at. It might not apply if you just have a generic reference to the ability to take military leave under applicable law. So those are the updates on the leave. And then just to round out my section before I pass it back to Sam, there was one additional change, and this is continuing the trend that we see for industry-specific legislation in California. There was a farm worker labor relations bill that changes the ability of farm workers to unionize through a representative ballot card. Before their union election had to be by secret election, but at a polling place designated by the Labor Relations Board, the Agricultural Labor Relations Board. So this is intended to make it a little bit easier to conduct those elections and reduce some of the perceived issues of intimidation when voting to unionize. This is versions of a similar bill have come before Governor Newsom before, and he has vetoed them. So this was a more watered down version of the bill, which he ultimately signed. And with that, I'll pass it over to Sam. Thanks.
I'll just add that on that farm worker union organizing bill, it's, the California legislature has had real interest in expanding unionization, organizing rights. And so the idea, and there's been some efforts on the federal level as well, but the idea is to make it easier for farm workers to unionize. The justification is this question of intimidation. I think many farm agricultural employers would disagree, but that's basically been the justification to provide a mechanism to expand union organizing in the agricultural sector.
Okay, so ever since the start of the Me Too movement a couple of years ago, California has always been at the forefront of legislating to protect workers from sexual violence and human trafficking. 2023 is no different, and it brings a variety of very industry-specific updates. So employers in these industries should definitely be aware of these changes to the laws, but all employers should be aware and be sure to stay updated on any sexual violence or human trafficking laws that apply to employers generally. You'll see a lot of these are very industry specific. So any employers in these industries should be aware. So the first one is has to do with the hotel industry. It's one of the industries that has historically had focused legislation on human trafficking, mostly due to the nature of a hotel's business and the fact that there's private rooms and anybody can really just buy a night in one of them. So now a hotel can be issued civil penalties ranging from $1,000 to $10,000 under two circumstances. The first is if a supervisor knows or acted with reckless disregard of sex trafficking within the hotel and failed to inform law enforcement. And the second is if a supervisor participated in a venture that the supervisor knew or should have known constitutes sex trafficking. So here, it's just really important that hotel employers be sure that their supervisors are trained on what constitutes sex trafficking and also what they should do in the event that they are privy to or become aware of sex trafficking within the hotel that they work at. You can go to the next slide, Megan. So this is another example of industry-specific legislation. It's probably a very narrow one, but we figured we would flag it. So starting next year, the law is in effect, but it begins next year. Newly licensed EMTs will be required to complete at least 20 minutes of human trafficking training. And then there's just a carve out that existing EMTs or paramedics are not required to complete this training. It only applies to those that are newly licensed. So this is not industry specific, so all employers should be aware of this one. It's a relatively minor update to the state Safe at Home program, but it is an update that applies to all employers. So this program offers a substitute mailing address for reproductive health care workers, as well as victims of domestic violence, stalking, sexual assault, human trafficking, elder and dependent abuse. And what the update does is it expands the currently you're not allowed to sell, solicit, or put people's home address on anywhere in a public space. And this broadens that requirement to include the internet. So all the places that were covered before still apply, and now the internet is also covered by this law. So it's just important that employers be aware that if they know an employee is in this program, that they don't publish their address, home phone number, or image anywhere on the internet. Two more industry specific requirements. The first one is education. So private colleges and post-secondary schools are now required to post educational and preventative information on sexual violence on their internal campus sites. And then beginning next year in 2024, September of 2024, they're going to have to provide annual training to students on sexual violence and sexual harassment. So these also apply to public schools, but it's important to know that independent and private schools are also included. In terms of barbering and cosmetology, there's now a requirement that those employers post a notice containing information relating to slavery and human trafficking within the workplace, and the penalties for failing to do so can range anywhere from $500 to $1,000 for each violation of that requirement. So California consistently legislates in the area of wage and hour. We all know there's extensive laws in this area, and 2023 is no exception to that. So we'll cover some of the updates this year. So the Cal Warren Act is not often updated, but this year brought some updates specifically related to call centers. The Cal Warren Act requires written notice in the event of certain layoffs, mass layoffs, relocations, and terminations. The 2023 update requires the EDD to publish a list of call center employers who operate a call center and provided the Cal Warren notice that year. And they're required to publish this list semi-annually. It also includes ramifications for call center employers who fail to provide the required Warren notice when the Cal Warren Act would require it. And those ramifications include grant and tax ramifications listed on the slides. The Cal Warren Act has some nuances about when this notice is triggered. So if anyone on the webinar has questions about it, you can definitely feel free to reach out to us and we can kind of walk you through the requirements. Another update is in the area of public works contracts. So prevailing wage laws tend to be updated from year to year, and 2023 is no different. It includes a new expansion. So the new area of public work that would trigger prevailing wage laws is the hauling of refuse from a public work site to an outside disposal location. And there's certain circumstances in the law that limit that. And then the second is the on-hauling of materials used for paving, grading, and fill onto a public work site if the individual driver's work is integrated into the flow process of construction. So there's some nuances there, but for those engaged in public works construction projects, you definitely want to be aware of these new expansions of the prevailing wage requirements. So AB 2206 is apparently California's climate initiatives and employment law coming together, which I didn't know we would ever see that, but here we are. Employers with 50 or more employees who provide a parking subsidy to employees and who can also reduce the number of paid parking spaces they maintain are now required to offer a cash out program to their employees. So in the event that they subsidize parking, you have to give the employees an option to receive the subsidy in cash and not in parking. And this is probably to encourage carpooling or alternative modes of transportation to work, and in the effort for California to reduce its carbon emissions. So those are some of the updates in wage and hour. It was a relatively light year, but just be aware of these updates. And with that, I'll turn it over to Andrew to talk about employee protections for cannabis use.
Okay, and I would just add to that it's probably not light for most states in this country, but in California, I think we had a little bit more volume in legislation last year. But one piece of legislation that's really impactful is this new law concerning cannabis use. I did want to mention that if there are any questions, you can type them into the chat function, and we're going to leave some time at the end to answer questions. So just go ahead. Anything that's come up so far continues through the end of the presentation. Just type in your questions, and we'll address them. Now, regarding this new bill concerning cannabis use, it's AB 2188, and there have been several efforts over the years by the California legislature to curtail California law to impede the ability of employers to test for marijuana use. Some of the bills have been vetoed. This one, after years of efforts, made it into law. And as some important context here, in California, the voters passed Proposition 215 in 1996. That was called the Compassionate Use Act, and that allowed marijuana use for medicinal purposes. And then in 2016, Proposition 64 was passed by the voters, making recreational marijuana use legal. Now, before Proposition 64 passed regarding recreational use, and after Proposition 215, the Compassionate Use Act, the California Supreme Court weighed in on whether an employer had an obligation to accommodate an employee for the use of marijuana for medicinal purposes. And the issue in that case, the case was called Ross versus Raging Wire Communications. And in that case, the employer conducted pre-employment drug testing for a variety of substances, including marijuana use. And the test came out positive for marijuana use, and as a result, I believe the employee's offer was withdrawn, offer of employment. And so the court found that there was no obligation to accommodate a disabled employee's use of marijuana, whether the marijuana was being used off premises or on premises, it didn't matter. So it gave employers carte blanche to conduct testing for marijuana use without any consideration of when the marijuana was actually consumed. And the logic in that case was that, for the decision, was that marijuana remains a controlled substance, outlawed under federal law, and that the Compassionate Use Act did not address any rights with respect to marijuana use in the employment relationship. And Proposition 64 similarly didn't address whether marijuana use was permissible in the employment context. So we've always read Ross versus Raging Wire as providing ample support for employers. Now that is in conducting drug testing for marijuana use. Now that has changed with AB 2188. It's important to note that this law does not take effect until January 1st of next year. So you have a little under a year to come into compliance. The reason I understand for the delayed effective date was because of the availability of testing that would be required to test within the constraints of this new law. So we'll see, hopefully the testing capacity is available at that point. But it is important to prepare for this effective date because it is fairly broad in its application. It makes it unlawful for an employer to discriminate against an applicant or employee in hiring, termination, or any other term of condition or of employment, or penalizing a person based on these two categories. One is the individual's use of cannabis off the job and away from the workplace. So if you learn that an employee has consumed cannabis outside of the workplace, then you cannot discipline that employee based on that. The other, that's a bit less problematic in some ways than the second factor, which is an employer that basically the employer cannot discriminate against an employee based on employer-required drug screening tests that has found the person to have non-psychoactive cannabis metabolites in hair, blood, urine, or other bodily fluids. And the idea is that a non-psychoactive cannabis metabolite would be if there's THC that's in the system. After it metabolizes, there's a question about the timing of the consumption of that cannabis product. And so the law prevents testing for the metabolite. Now let's go to the next slide and I can break this down a little bit. So most marijuana tests show only the presence of recently metabolized cannabis rather than active THC. And that THC is a chemical in cannabis that can cause psychoactive effects. CBD, another component of cannabis, there hasn't been effective tests for screening CBD, but there have been some forms of CBD that has had traces of THC that can come out in a drug test. Now, the law prohibits employers from relying on tests that measure only cannabis metabolites. And the idea, as I indicated, is that cannabis metabolites could be the cannabis that is detected, but not showing any sort of active impairment by the employee at the time of the test. Now, there are several types of tests that can be conducted. You have urine tests, hair follicle tests, and saliva and blood tests. And all of them measure THC in different forms. The urine test tends to measure metabolized THC that has been excreted, so that can no longer be conducted under this new law. A hair follicle test tends to measure cannabis that occurred weeks or months earlier, so that does not measure or detect an active impairment, so a hair follicle test can no longer be conducted. The two tests that are permissible based on current technology would be the saliva or blood test, but you need to make sure that the test only measures active THC, not metabolized THC. So it'll be important that you have a dialogue with your testing facility or supplier of the tests if you're going to conduct the testing yourself, to ensure that the test measures the correct component of THC so that it does not violate the law. You could get into hot water if you find that you're not testing properly and you're detecting a metabolized THC, and that somehow is being disclosed to the employer in a way that could create some legal exposure. So let's go to the next slide here. So what does this all mean? You can still conduct pre-employment drug testing. That's clear from the new law. but there's a question about the utility of that because you can only screen for non-psychoactive cannabis metabolites. You can also conduct a post-action testing, and that would seem to have the most value where you believe an employee, where there's the probability of an employee being under the impairment of THC, marijuana at that time of the incident. It's important that if you do post-action testing, that you ensure that you have a compliant drug testing program where you're providing advance notice to employees of the testing criteria, and that there's only certain circumstances in which you can conduct post-action testing. It cannot be done across the board. There are some significant carve-outs to the law. I certainly believe that they're not far-reaching enough, that really, this law should exclude any safety-sensitive positions. So there is a carve-out for building and construction trades, which would typically involve safety-sensitive positions, so positions where there's a reasonable probability of serious injury or damage to property. But there's other industries where there's certainly safety-sensitive positions that are not incorporated as an exception that are, deeply problematic. The other carve-out is for positions requiring a federal government background investigation or security clearance under the Department of Defense regulations, or equivalent regulations applicable to other agencies. Now that's pretty vague, that last quote, and so hopefully there will be some FAQs issued by the Labor Commissioner or other agencies in the state that provide some clarification for what that means. It does state the bill or the law that it does not preempt state or federal laws requiring testing of applicants or employees as a condition of employment. So I would see that applying to state agencies that require drug testing, whether that be for social services, could be skilled nursing or some other facility where there's a requirement for drug testing. Actually, offhand, I don't recall if there is a requirement there, but if there is a state agency that does mandate or federal agency drug testing, there should be an exemption considered, but something you'd want to review carefully with counsel. Okay, so that's the nuts and bolts of the cannabis law. I expect we will be covering this again next year as we have the effective date, but we thought it was so significant that it should be briefed this year in advance of its effective date. Now, there have been some developments in the workplace safety space, and that's the next subject here. There are various rulemaking developments by the Cal OSHA Standards Board. We're not addressing those today. Those will be addressed in our Cal OSHA specific webinar next month. So if you're interested in those, please do attend. We are just discussing some legislation in the workplace safety space. Let's turn to the next slide, discuss the first one. Now, this is interesting. With Cal OSHA, we have a heat illness prevention standard. We also have a wildfire smoke standard. These standards have gone through rather extensive rulemaking, and I would say almost it's painstaking rulemaking that has gone through various iterations and has received stakeholder input and considered by DOSH, which is the enforcement agency, tasked with drafting these rules. Now, the legislature has intervened in a way that, I frankly consider meddling and having no effective value. But they are requiring DOSH by December 1st of 2025 to submit a proposal requiring employers to distribute a heat illness prevention plan to employees upon hire and upon receiving heat illness prevention training, which has to occur at least this distribution has to, in any case, be at least once a year. Now, there's, as I mentioned, there's questionable utility here. The heat illness standard already requires that the heat illness prevention program that an employer must have where there is outdoor work, that it be available at the work site to employees. So okay, so we just clarify that it has to be distributed to employees. Is that really needed? Is this something that the legislature needs to weigh in on? The other area is in the space of farm worker employment. And again, this is an area like with labor laws where the legislature is taking an active interest. They want to here require DOSH to submit a proposal to revise the wildfire smoke standard to reduce the air quality index at which respiratory protection is required. And so this does not mandate certain rules, but requires DOSH to submit a proposal, which would then go to the standards board, and the standards board would need to make the decision whether to adopt it. But what I find striking is that this is only specific to farm workers, not all employers, and questionable, why we are singling out agricultural employers in this context, and what is the empirical basis for this? And it didn't appear to be all that supportive of the standard. In any case, this is in the works. And then there's another workplace safety development. If you can turn to the next slide. And this one has gotten quite a bit of attention. It's requiring the establishment of a fast food council. Again, it's targeting a specific industry. And here, there's been a lot of attention in the press over the fast food industry and the wages and efforts to unionize. And so this law requires the creation of or effectively creates a fast food council, which will apply minimum workplace standards for workers at any fast food restaurant. And it's really a chain fast food restaurant, a food or beverage company that has 100 or more establishments nationally sharing the same common brand. So it's very tailored to a certain business. And the Fast Food Council will conduct a review of the adequacy of the minimum fast food restaurant health, safety, and employment standards, including minimum wages, and will adopt certain standards. And there's some ambiguity about how that will come about. And that the California Labor Commissioner can investigate employee claims for workplace standard violations by fast food workers. And so although the council can develop certain rules, they cannot develop workplace safety rules for fast food workers. Instead, they must petition the California Standards Board for the adoption of those rules. It's interesting too that this law essentially requires or empowers the council to engage with the governor and with the executive agencies on this, meaning that they are the voice on these issues and will influence state government. At least that's how this is envisioned. In any case, there is a initiative that's being considered on which signatures are being collected that would override this law, creating a fast food council. And as a result of that signature collection, a judge has stayed temporarily this law. So it's not in effect presently. We'll see what happens, whether the stay remains in effect, and what occurs with the initiative, assuming enough signatures are collected. So let's move to the next issue. This law has been under the radar largely, but this will be really significant for construction contractors. There has been a change in the law under AB 1747, making it a willful or deliberate disregard and violation of safety laws, grounds for disciplinary action by the California Contractor State Licensing Board. So the takeaway here, I mean, this is brief, but is that if you are subject to the California Contractor Licensing Board and you receive a Cal OSHA citation that is classified as willful, it's very important that you just not accept that citation. I would consult with OSHA counsel, and that's an area that we specialize in, about what your recourse is and potentially appealing the citation. Because having that willful citation on your record would seem to give the basis for the California Contractor Licensing Board to take disciplinary action, whether it be a suspension, revocation of licensing, or other action. So I think we have one more area to address. And in the next slide, that's electronic monitoring devices in vehicles. I'll be brief on this point. It will not impact, obviously, all of those employers attending. But if you are in a business where you have commercial drivers, there are many employers, for very good reason, that have monitoring devices in the vehicle, and they can accomplish a number of purposes, primarily to monitor the employee to ensure that the employee remains awake, to avoid an accident. And so there is technology that will monitor the employees. It can be the eyelids as they're blinking, and other signs that will indicate that the employee might be about to fall asleep or having actually fallen asleep, and to engage in measures to prevent an accident there. And so these have, great value. They're not abolished by this new law, but what the law does provide is that these devices can only be used during working hours and if strictly necessary for the employee to perform duties. And so there must be the ability of the employee to turn off that device while not working. So if the employee, for example, is sleeping in the truck, taking a break. And then there's certain disclosures that are required. And so, we recommend that you carefully consider all of the different requirements. We listed only some of them here, and that you provide written notice to employees of the use of this electronic device in the vehicle. If you have any questions, if this particularly impacts your employer, feel free to reach out. But let's move to the end. So we have some takeaways here before we get into the questions. There are many more takeaways that we could have, but I think that the biggest areas are really over the pay data reports that Megan covered. Those are incredibly consequential, and that for your job posting and recruitment process that you need to disclose the salary ranges and make sure you're providing it in the format that's required, as Megan discussed previously. You also want to update the leave policies. It's regrettable because I feel like California employees need to update leave policies annually, and so it's pretty taxing. But this year it certainly has some additional requirements, maybe not as substantive as past years, but still enough to justify updating your personnel policies. And then there's a variety of wage and hour changes, human trafficking, avoidance mandates that are specific to industries, and if it impacts your industry, you'll want to update your policies accordingly. For the new cannabis law, you can wait until the end of next year to update your policy on that, but this is a good time to consider how you're going to consider testing for marijuana use in the future, ensuring that you're compliant with that new law. So let's move to some of these questions here. Okay, here's one on cannabis use. I can just answer this and then we'll continue down. How do you determine non-psychoactive cannabis metabolites? Do you recommend adjusting to reasonable suspicion testing? Now that's a highly technical question. It's the nature of the test, and what's key here is that your testing provider or the testing kit that you have has to focus on active THC and be able to test that, and that can be done under certain testing, though there have been limited supplies of that will hopefully increase by year's end. But if it has metabolized, that's not something that can be tested for. And you also ask, do you recommend adjusting to reasonable suspicion testing? Reasonable suspicion testing can be done, and that's a tricky question, because first of all, if you're going to do reasonable suspicion testing, you have to ensure that the person who's identifying, who's determining that there's a reasonable basis to believe that there's an impairment, that you have to make sure that person's adequately trained, understands what the signs may be of impairment. It's not always clear. There can be impairment, there can be signs of impairment that could relate to some other issue. It could be relating to a disability or potentially a prescription drug that's being used by the employee. So you can, as long as it's done effectively, you can have reasonable suspicion testing, but then when you actually conduct the testing, you'll want to make sure that the testing is not detecting the THC metabolite. Okay. There was a question about, do you see the ban on independent truck drivers being extended to other occupations, such as construction? Did anyone want to answer that? The ban on...
I'm not sure what that's, I'm not sure the context in which that, I know the question came in when we were talking about testing. So I imagine that's a question for different contexts. So I'm not entirely sure.
Okay.
I don't know if it's a reference to independent contractor analysis, which there wasn't any update to. There's been a series of changes to the independent contractor rules in California that, generally there's an ABC test that's in effect now, and there's been some legislative carve outs for various industries. And there have been, over the last few years, some updates to that to add some carve outs, to extend some carve outs that were in the original legislation, but we did not see a further update to AB 5 in 2023.
And I have another question that's perfect for Megan. That's for the new bereavement leave law under CIFRA. Do they still need to be with the company for 12 months and have worked a minimum of 1,250 hours?
That's a great question. There is a specific requirement that they be with the company for 30 days prior to the leave, but I'd have to double check to see if the general CIFRA eligibility also applies to for bereavement leave.
Okay, but for CIFRA, that's been the requirement as well.
That's the general, yep.
Under the FMLA.
Yep, so I'd imagine that it would be both general CIFRA eligibility plus the 30-day eligibility specific to bereavement.
Okay. Okay, well, we are going to conclude the webinar. Feel free to reach out to us independently if there's something we weren't able to address today. I don't know, Megan, if you want to show the slide with the blogs that we have. Yep. But as a reminder, I think it's on the prior slide. Well, that's our contact information that you got, and the SHRM provider information. But we do have blogs, and you can subscribe to any of them. You just go to the blog and put in your email address, and you'll get our regular updates. We have OSHA as well as a Cal OSHA blog and an employer defense blog. The employer defense blog is focused on employment and litigation, certainly lots of California developments. And then we have a webinar series on employment law as well as OSHA. And we have actually those of you that are really interested in the drug testing issues, there will be a drug testing webinar in July later in the year. And there'll also be a webinar in April on pay transparency. So we expect some of the issues that we discussed today to come up again in these future webinars. Well, thanks again for participating. We really appreciate it.